about restaurants that serve alcohol.
Mm-hmm.
And it's the same in California, the same in Hawaii, everywhere else passes these laws. So I'll tell you a story from my childhood. I used to play soccer as a youth. And after that, we would go to Round Table Pizza. All the kids and their parents would go to Round Table Pizza. We'd have pizza. And guess what? Round Table's Pizza served beer. This isn't a rowdy bar situation. It's not a high security threat. Fights are not breaking out at Round Table Pizza after the youth soccer games. Rather, occasionally, maybe a parent would have a beer. And if their significant other was there to drive, who knows? Maybe they'd have a second beer. That is not a justification to say that you need to be stripped of a constitutional right because people other than you happen to be enjoying a beer. That's not what they're trying to paint this out to. They're trying to paint this out as some sort of Wild West saloons. When in reality, this lots and lots of restaurants serve beer. And we're not challenging the requirement that you can't carry when you're drinking. We're saying because this law just prohibits you, even if you're just in there.
Yeah.
So there are dozens and dozens and dozens of businesses that happen to serve beer and wine on there. And guess what? Lots of people coming home late after work want to stop in, have a bite to eat. You get off work, you work the late shift, coming home from work at 10, 11 o'clock at night. You don't want to have, go home and spend an hour making dinner. Come in, you go to, where we got Zippies in Hawaii, or maybe a Round Table Pizza, right? And all of a sudden, now you're a criminal because you decide to sit down to have dinner and you happen to have a CCW to protect yourself. That's not okay. It's not right. It's certainly not constitutional. And that's absolutely not what our founding fathers intended for a vision of this country. I happen to serve in a branch of the military which was founded in a bar, and that's the conception of Tun Tavern. So that's the conception of what this country is founded upon.
I just got motivated right now. Let me do some push-ups.
Yeah. Well, put the camera on you while you're doing that. It's historically at the time of the founding, we have had a history of political discourse in taverns, of people going to restaurants that served alcohol to go and they would carry guns and they would have weighty political discussions. A branch of the armed forces, the U.S. Marines, was created in a bar. The American Revolution was created in a bar by armed Americans, and they weren't armed because they were planning on having a revolution right then and there. That was just simply part of their day-to-day life, where they would have to walk home after that. And guess what? They might need to defend themselves.
Amen.
Especially in the state of California, state of Hawaii, New York, Maryland, New Jersey, have all decided that they're going to spit in the face of our American traditions and of the Second Amendment by, disarming people who are trying to go by their day-to-day lives. Two of my clients, they go and they both own their own businesses. They regularly go to the bank, drop off money, do payroll, and after that, they go sometimes have lunch. That's what they do. You get something to eat, you go to the bank, drop off some money. Heck, you go back to work. Then, if you have a little bit of time, maybe you'll take a walk on the beach. All these locations, in the course of a day-to-day life, the state of Hawaii and the state of California, New York, New Jersey, and Maryland thinks is you should be defenseless if you're attacked, and that's just something that violates the Second Amendment. That violates our American history.
If they wanted to do something the way they're trying to do it through the courts, they should seek a constitutional amendment to amend the Constitution instead of trying to use judges to try to rewrite the Constitution.
And that's absolutely true. And it's more to the point. We have to look and just see. I mean, the Supreme Court has spoken. This is not a situation where the states are acting in good faith. Maybe this is some sort of, gray area where we need to have some real deliberation. I can understand that. Maybe we work that out in the legislature. Maybe there would be no need to cast aspersions at the drafters of these bills. But this hasn't been done in good faith. This has been done wholeheartedly as an attack on the U.S. Supreme Court's jurisprudence, and because they didn't like what the Supreme Court said, they wanted to try and push back. And that's in the legislative history of all these bills. They're very much being defiant. And more to the point, there's a belief that the Supreme Court's decision was not legitimate. The drafters of this legislation, that are typically, liberals, they are very much hoping that they will outlive the Supreme Court, at least the current composition of the Supreme Court.
Right. Yeah, that's what I'm hearing too. Yeah.
Yeah. So I think that's a little bit outrageous, and it particularly hurts Californians that live in rural areas, because rural California actually has always been shall issue. Most counties in California freely handed out concealed carry permits even prior to the Bruin decision.
So just really quick, Alan, maybe some of my viewers don't know what shall issue is as opposed to issued for cause.
That means that if you went through all the hoops, paid your fee, and said, I want a CCW for self-defense, you could get a permit. And they would automatically give you a permit as long as you're a law-abiding person.
That's shall issue.
Correct.
And then in Los Angeles, how was it?
You had to show a significant amount of justification.
And who got to decide but if you had a valid
police?
Oh, okay. And how many of those were issued, do you think, a year?
Oh, I think as a practical matter, while, I guess a couple dozen were issued every year, it was only if you're connected.
Yeah.
I don't think that it's an average person without any connections to politics would, could get one. Anyway, that's what's happening nationally here. This is the hot button issue being litigated in the courts. The California case, the New York case, the New Jersey case, the Maryland case. They're setting out the groundwork. There's a few other cases. For example, in New Mexico, the governor passed this egregious law order. She didn't do it through the democratic process. She did it by fiat, which is not technically the word is executive order. That's her essentially saying that she's declaring a public emergency through her own power. And that was struck in court. However, she immediately changed the law. The executive order to just ban in parks. And the trial courts have a split on that issue. Now, one upheld the law, the other one enjoined the law. And now that issue is going before the 10th Circuit Court of Appeals. And a separate case is in front of the New Mexico Supreme Court saying she didn't have the authority to issue that order. So it's not a Second Amendment case, unlike the 10th Circuit case.
Interesting. So as a matter of housekeeping, Dick Hiller mentioned to ask you about, I believe it was a Maryland case where a judge, it might have been dicta, said it doesn't make sense if you have a concealed carry that you can't walk across state lines and have it there. And I thought that made a lot of sense because it sounds sort of like a full faith and credit issue. But I wanted to get that because we only have a couple minutes left on this podcast.
Yeah, I'm not familiar with that particular line. I think he's referring to the Maryland shall issue case, and that's